He has come all the way from Bangalore. We had opportunity to listen to him for our international tax RRC in Bangalore this year itself. He had given a talk on taxation on cross-border transactions. He had given us just 8 or 9 page note, and we asked him, sir, this is a 1.5 hour conference. Would you be able to give justice? It's only 8 page. He says, Mr. Doshi, we can take this 8 page for at least 1 full day. Please look at it, how I conduct the conference. And really, we have given him 2 hours, 15 minutes, but then we have to tell him, please stop, because we don't have enough time. I request Manish to formally introduce Mr. Raghuraman and take it further.
Thank you, Inesh bhai. Good morning, friends. Good morning. We have Advocate V. Raghuraman, who has given a beautiful paper on the case studies on Senate credit mechanism, which is the most complicated topic as far as service tax is concerned. As far as Raghuraman is concerned, he is practicing advocate and by qualification chartered accountant also, practicing since last 23 years. He specializes in excise, custom, service tax, foreign trade policy, FEMA. He also undertake indirect tax planning and litigation and appear frequently before courts. He is a visiting faculty at IIM Bengaluru as well at CA Institute. He has addressed a large number of seminars and published several papers in national magazines on excise, custom and service tax. He is the author of a book, Landmark Decision in Indirect Taxation, published by CCH. He has authored Central Excise Law and Procedure, published by RK Jain. And he has given background material on e-learning courses on service tax, which was published by ICI. With these few words, I welcome Advocate Raghuraman for the presentation of his paper. Thank you. Before that, I request Hinesh Doshi to kindly present a memento as a token of our love and appreciation to the paper writer.
At the outset, I would like to thank the Chamber of Tax Consultants and its advisor, Mr. Krishnan, for inviting me to this. I would call it you call it a refresher course on service tax. I would call it a learning course on service tax for the people who attend and the people who set the papers. Equally, it is a experience for us to share our thoughts. I'm more looking at exchange of thoughts rather than saying that it's not going to be a one-sided dialogue. The interactions yesterday were as expected, of a very high order, which you can expect from people who come to this Chamber of Tax Consultants and BCAs. And I was happy to be, I would have been probably happier if I had spent a little more time also seeing more of the interactions, because it was pretty good. The first session, we had some wonderful questions which were there set by the paper writer, on issues which probably will be settled at the time when we have grandsons. Some of the issues that we would deal with in Senvat Credit also have been going on for quite a long time. Really, if you look at the history of Senvat, what it was called initially in 1986, it was called ModVat, Modified Value Added Tax. And when the invoice system, this is essentially in excise, in invoice system came into vogue, we had ModVat credit cases coming up by the day, not by once in a while, by the day. So after between 1994 to 1997, we had rechristened ModVat as MadVat. We were unable to handle litigation in ModVat, actually, to tell you the truth. And after capital goods credit came, it only became worse. For a brief period in the early 2000s, it was a little relaxed as far as credit mechanism was concerned. And we were quite happy that it looked to be settling till such time they undid the definitions of input service in 2011. Which is a subject matter of one of the questions here also. So now we are probably back to handling more and more Senvat credit matters. And therefore this session will have some seminal importance to all of us. Now let us look at the first question which is there. Really, the first question is on utilization of Senvat credit. The issue is on utilization of Senvat credit. I was happy to see that one of the groups had gone into availment also, though that question was not asked. I think it was the Parwana group which had dealt with on availment also. In this question, essentially, the person who is availing the credit has availed certain credit on construction services, has also let out some portions of the property on rent. One of the issues that comes up in these matters is this. Supposing I construct a commercial property, I take the services of a contractor to construct the commercial property. After that, I leave it on rent. So, on the rental on the immovable property services, I pay service tax. The issue is whether can I take credit on the contractor's service tax. That becomes the issue. I hope you have understood the gamut. Can I set off the works contract tax that I have paid on the input side against the rental of immovable property which I receive on the output side is the short question which arises. Now there is a board circular, I understand, which has said you can't do it. There is a decision of the Andhra Pradesh High Court in Sai Samhita Storage 270 ELT which says that the facts there were that they took credit on steel and cement. In fact, this case is on better footing than that case. They took credit on steel and cement to build a warehouse. That warehouse was let out for warehousing services. There the Andhra Pradesh High Court held, yes, without the steel and cement you can't put up a warehouse. So perfectly you are entitled to credit. In this case also the credit has been availed in 2010. Validly availed. Can that credit be utilized is the question. So all the three groups are unanimous on the fact that the credit can be utilized for payment on rental, for payment on construction activities. But when it comes to the reverse charge mechanism, the group says you cannot utilize the credit, but you should pay it by cash. Right? All the three groups have said, when it comes to reverse charge mechanism, you will have to necessarily pay the tax by cash. What is the reason for that? You have referred to an explanation under 3(4), which was inserted with effect from 1/7/2012. That explanation says that you cannot utilize the credit for payment if you are the service recipient. Right? One other question which I would like to pose to all of you is this. When I go under partial reverse charge mechanism, can it be said I am providing output service? Can it be said, is it no? Is it yes? Or is it half yes, half no, as somebody has told? Please look at the definition of output service. Please go there and see. Output service would tell you that it does not include a service on which the whole of the tax is payable by the recipient. Whole of the tax. Therefore, it becomes an output service. There is no question that there is no question of saying that it is partial output service. It is output service, in my view. If that be the case, if a part of the tax is payable by the service recipient and only a part is payable by the service provider, will explanation to 3(4) work or not is the question. Are you following what I am saying? The explanation does not say whole of the tax payable by the service recipient. Please see explanation 3(4). I will come to both the arguments which can be taken. In 3(4), what does it say, the explanation? Well, tax is payable by the service recipient. So the department's argument should and would be that even if a portion of the tax is payable by you, you cannot utilize the SENVAT credit. Well, our argument should be that if tax is payable by both, the question of the tax being paid by the service recipient does not arise exclusively. And therefore, you should be able to utilize the SENVAT credit. My view would be the latter, because we revel in litigation. We have to test this and see whether this 3(4) should be read along with the output service definition, or it should be read dehorse this. I would say it should be read along with, and those who are under the partial reverse charge mechanism must be given the facility to use SENVAT credit for the purpose of payment. That is my view. Any questions on this? We come to the next question, which is fairly simple. I think all of you have come to the conclusion that when an asset is destroyed, there is an insurance claim that is paid to the person who avails SENVAT credit. There has been a lot of disputes on this across the country, that when an insurance claim is received, the department says you should reverse the credit because there is a double benefit. On the one hand, you have got SENVAT credit. On the other hand, you have also got the insurance claim which covers the cost of the asset completely, including the SENVAT credit. So it's the department's view that you must reverse the SENVAT credit. All of you have taken a view that there is no need to reverse. That view is absolutely right for one reason. I had an opportunity to argue this case before the Karnataka High Court. Tata Advanced Materials, 271 ELT. I made only one submission. Kindly ask the department to show me which provision of SENVAT credit rules requires me to reverse the credit when I get insurance claim. And they failed to do so. Just on that limited ground I won that matter. Nothing more than that. There is no statutory provision which says that because you receive insurance which includes the SENVAT amount, you must reverse the credit. Simple proposition of law. Sometimes the most complicated cases are won on most simple propositions of law. This is one. There was, however, a difference of opinion, I think, on the payment of 10,000 rupees which was discharged on the scrap. There was one group which said that if an asset is put to use and then removed, the question of payment of tax will not arise, because that is only applicable to removal of assets as such. That was one view. One of the groups said, I think they said specifically that that rule applies only to manufacturers and not service providers. That was one view. This is a rather, vexed question, because we have been arguing these matters before the tribunal and it is pending. Whether these things, when they say specifically only a manufacturer, whether it will apply to an output service provider, it is very clear. If the provision of law does not refer to a service provider at all, the question of attracting payment of tax doesn't arise. 1. 2. There is a difference between removal as such and removal after usage. When I use the goods and then subject it to removal, when I use the goods and then subject it to removal, then there is a usage. Now, what do you mean by as such and what do you mean by removal? When I get the goods, it is kept in my factory, let us say, for a couple of months. Can you say I have used the goods? Can it be said that I have used the goods? What do you mean by usage? What do you mean by consumption? It is just lying there. Can I say it is used? If it absolutely ready to use, but I am not able to use, what happens? What do you mean by put to use? Intention to use. What do you mean? I have the intention to use. Yes. Now, why I am asking you the questions is, we are not sure what is as such and what is use. I will give you a parallel. It strikes me now. I give you a parallel with Section 74 of the Customs Act. If I import goods and re-export them, and the identity is established under Section 74 of the Customs Act, I am entitled to drawback up to 98%. There is a schedule there which says up to 98% you can claim drawback. The issue before the Karnataka High Court in Kemble's case was whether machinery which is imported for the purpose of exhibition can you say that it is put to use? A fair or exhibition is conducted in the country, machinery is imported. Nothing is done, it is just on display. After the exhibition completes, maybe 1 month or 1.5 months, it is re-exported. The assessee wanted to say that the machine is not at all put to use, which is what commonly we would think so. But the High Court said, no. Your activity of putting the machine in a fair or exhibition is putting it to use. Because you have imported it for the purpose of exhibition. That is use.
If it is used by somebody, I rent it out and I charge service tax on that.
Then there is no doubt on those. There is absolutely no doubt that I put it to use. Here is a question where it is lying there. I have not even touched it. So we may not, why I am drawing the parallel from Customs Act is just to show you that there could be decisions on other legislations which have interpreted not used as such almost similarly. But we need not be bound by the Customs Act decision. We can distinguish it by saying that what is there in Senvat credit rules is when I actually put it to use in the manufacture. This is one way of handling it. Unfortunately, in capital goods credit, if you see the difference in definition of inputs and capital goods which were there prior to 2011 and now, what is the difference? Has anybody noticed the difference after 2011 in the definition of inputs and especially inputs? Capital goods has remained more or less the same. In inputs, the earlier was it should be used in or in relation to manufacture. Today it should be used in the factory. Straight away, if you have goods which are used in the factory, you are entitled for Senvat credit. And even if you have a remote connection to usage, because it says no connection whatsoever, that is how the inputs definition says. No connection whatsoever. That means a remote connection is also enough in inputs. So to answer this question, coming back, I would say that if you have put this, in my view, if you have issued anything to production, if you have put a facility in the production floor or in any part of your premises with the intention that it should be used, whether it is used or not, it is used. There is no removal as such. If you have put it in the production floor, capital goods, it is used. Whether you actually physically use it or not, it is used. And therefore, there is no removal as such. As such means absolutely you have not used it at all. So that would be my view on this. And therefore, I think you are right in saying on both the counts that the tax should not have been paid at all. Even the 10,000 rupees that they paid should not have been paid. The third question is very interesting. I was witness to some very agitated arguments on the third question. What really is the issue here? There is a job worker. Let us assume that I am the job worker. And you are the principal manufacturer. Now I am manufacturing certain goods for you. The process does not amount to manufacture. I send the goods to you. You are the principal manufacturer. You finish the goods and clear it on payment of duty. So I am claiming the exemption under 25/2012, which was earlier 8/2005. The issue is, can you call this as exempted clearances or exempted services? That is the issue. If you can call it as an exempted service, then I cannot retain the full Senvat credit. If I can say this is not exempted services, then I can retain the credit and I need not go to Rule 6 at all. This is the question. I had visited one of the groups, that is, I am told that among all the 3 groups, there are only 2 people who said that there is no need to reverse. The rest of the group were very clear that it is an exempted, yes, it is exempted service because you have taken the benefit of 25/2012. I had an occasion to argue this matter before the tribunal. It is reported in TIOL, that is Tax India Online, 2013. MGM Springs case. Facts are similar. But that is for a manufacturer. But he is doing the same job work. The 2 people I don't know who those 2 people are. I think who are the 2 people? Please raise their hands. I can see him. He is the leader of which group was that? Parwana group. Who was discussing Sterlite Industries large bench decision 183 ELT. If I am right. That is the correct answer. There is a difference between clearance under an exemption notification which is unconditional and which is conditional. If the notification is conditional, the clearance is not an exempted clearance or an exempted service. It becomes a taxable service subjected to a conditional exemption. In a job work, what we should explore is this. Please look at Rule 4(5). 4(5) of the Senvat credit rules. If you look at 4(5) of the Senvat credit rules, anything that is sent on job work to you is sent back to him on the condition that the principal manufacturer will be discharging the duty liability. That is also the condition in the notification in 25/2012 or 8/2005 as the predecessor, that the principal manufacturer will discharge the duty. It is a conditional exemption. So in Sterlite Industries, the same thing was argued that when I clear something on a conditional exemption, what really happens if the exemption is not there? I pay the tax and he takes the credit. Simple. If you had told me, this is what I argued before the tribunal, let me put it in the same words. If you had visited and told me that tax was payable, I would have jolly well paid the tax and he would have taken credit. What do you get out of it? Nothing. What does the department get out of it? Nothing. Because whatever tax I pay, he takes credit. It's a revenue neutral situation. That is the reason why they have given this conditional exemption. So therefore, conditional exemptions, if you find any clearance against a conditional exemption notification, it is not an exempt service or an exempt clearance. It is a taxable clearance. And the provisions of Rule 6 will operate to include this as one of the taxable clearances. That is the ratio of the decision in Sterlite Industries case. It was good to see the group leader being shut out literally in his arguments. It was difficult. I was just wondering, if this department had really outshouted me like this, I would have found it difficult to argue the case. Nevertheless, the principle of law is this: if there is a conditional exemption, not an absolute exemption, it's a taxable service. The other issue which was raised incidentally were that can it be said that it is an absolute exemption or is it that we are forced to take an exemption notification? In service tax, are exemption notifications optional or are you forced to take it. See, in section 5A of the Excise Act, there are absolute exemption notifications which operate absolutely on you. You have no choice when it comes to an exemption notification under section 5A of the Central Excise Act. But such similar provision is not found in service tax. And therefore, in service tax as of today, exemption notifications are optional. You can choose it, you can leave it. But if you choose it, you have no option but to follow it. You see that decision in the GD Builders case, Delhi High Court, decision 32 STR. GD Builders case, where they say if you choose erection, commissioning, installation, entry and the notifications therefrom, you have to follow it. Then don't come back and say 67% is not adequate or I will not follow this or no. You have chosen it, kindly follow it. In service tax, notifications are optional. You can choose to follow it, you can choose not to follow it. So my answer to 3 is Sterlite Industries will apply, sir.
So just one question on this. We were debating this particular issue on another study cycle as to whether the exemption notification should be considered as a mandatory thing or an optional thing. So one thought which was coming was that these exemption notifications are issued in under section 93, which can be issued only in the public interest. So when the question comes as to what is public interest, especially in the view of in the light of the indirect tax provisions, it says that the indirect tax is a destination-based tax, and that's why it is the ultimate consumer who suffers the incidence of this particular tax. So when it is a public interest and the government wants a particular service to be exempted in public interest, one needs to see that the incidence of that should not be passed on to the final customer. So whenever there is an exemption notification, one needs to mandatorily follow it in order to ensure that the incidence is not passed on to the final consumer. So what would be your argument on that particular aspect?
My argument on this is this. There is no entailment in taxation. If you want to make anything absolute, please say so. You have said so in 5A of the Excise Act. What stops you from saying so in 93? Even in 5A, notifications were issued in public interest. But what is issued by the government in public interest absolutely are subject to conditions. The person who actually opts for it, the person who actually has to pay the tax, is given an option whether you want to go or you don't want to go with it, because I will tell you why. The reason is, if he goes for an exemption, he is not entitled to SENVAT credit, or he is entitled to proportionate credit. Now I can opt for paying my tax fully and taking full SENVAT credit. I can opt for that. And the best mechanism for reducing prices is competition, not your forcing an exemption notification on somebody. And let me also tell you, why they forced excise exemption on to made it absolute so that people will follow it is only because they wanted reversals of SENVAT credit, not that they had issued it in public interest. Let's be clear on that. That's the other thing. One more thing which probably we should think of is, you have to revisit whether this service tax is a destination based consumption tax or not. Is it so? Where is it said so? Where is it said? I am sorry to say that the All India Tax Practitioners Federation decision in 7 STR, Supreme Court, which says service tax is a destination based consumption tax, is not borne out by the provisions of law. It seems to be a cut and paste job. I am sorry to say this, because it is not borne out by, what does it say? 64(1), what does it say? Taxable service provided. When you come to the 66B, taxable service provided or agreed to be provided. Can, if it were to be a destination based consumption tax, Can a person who provides services say that the consumer is refusing to pay the tax, I will not pay? Can you take that stance? If it was a destination-based consumption tax, as is what is being told after the Supreme Court decision, as they say, that is an economic concept. I'm not saying no. It's an economic concept. If that were the case, then you should say that if the consumer refuses to pay the tax, the person who produces the goods or renders the service should be out of the tax net. Go and recover it from the consumer. So I have a slightly different view on this destination-based consumption tax. I found it a preposterous observation. I don't lend any credence to it, because if that were the case, even some of the Delhi High Court decision which I saw, Pierli Lal Bhavan's case, for example, which is in 40 VST, which says the tax can be passed on and therefore should be recovered from the tenant. That is a contractual obligation. That has nothing to do with the service tax legislation. I think that is a totally wrong observation. You don't, that is a matter of civil dispute. It is not a tax dispute. Tax law is clear. The person who provides the service has to pay the tax. You can pass it on, you cannot pass it on. Whether it's very difficult to pass it on, that is your headache. That is my view. Yes, sir.
So you just stated.
No, please go ahead.
You stated that section 93, these exemptions in service tax in absence of provision like 5A, these are all optional. Then the certain notification like threshold exemption notification specifically provide it's optional. Then there is a need to provide that it is optional.
See, just because a delegated legislation says something is optional does not mean the parent is not optional. There are any number of other notifications which does not say it is optional. Why they are saying it is optional is because if you exercise the option, you have to follow some procedures, that's all. If you exercise this option, you file a declaration and say I am following this, for the rest of the financial year don't wriggle out of it. That is why that is conditioned. That is why they say it is optional. So it is to put some procedural conditions, they say it's optional. But it's a good question which you asked me. Let's look at the fourth question. In the fourth question, all of you were unanimous that the credit should lapse and there will be no question of carrying forward the credit by virtue of notification 33/2012. What does 33/2012 say? And before we come to that, I would have liked you all to notice the provisions of Rule 11 of the Senvat Credit Rules. Please look into it. Please take Rule 11 of the Senvat Credit Rules. None of us normally touch this. It is like a very rare provision which is touched. That is the reason why I just gave this, this is one of the compelling issues which, if you look at Rule 11, subclause 4 of the Senvat Credit Rules, what does it say? To my memory, it says, a provider of output services. You look at it very clearly. The provider of output service shall be required to pay an amount equivalent to the Senvat credit, if any, taken by him in respect of inputs received for providing the said service and lying in stock. Stop there. Almost the same thing is said in 33/2012. The question here, if you see, is that they have availed credit on input services, not on inputs. The question that will actually you should have asked yourself is this: if I have availed credit on input services, can it be said that it will lapse? By virtue of 11 bracket 4 or 33 bar 2012. What does this 11 bracket 4 say? After deducting the said amount from the balance of SENVAT credit, if any lying to in his credit, the balance, if any, still remaining shall lapse. No, does this balance refer to input credit or total SENVAT credit? That is the question. That is exactly the question which was asked. I have taken input service credit first of all. So nothing is going to be reversed. There are two aspects to 11 bracket 4. One is reversal of the amount, balance will lapse. Have you understood what I am saying? One is reversal of the amount. To the extent it is lying in stock, a reverse. The balance will lapse. Now, as far as reversal is concerned, I am not required to do the reversal because I have not taken input credit at all. I have only taken input services credit. As far as lapsing is concerned, can it be said the entire amount will lapse, or is it only in relation to the input credit? That is the question. Now, if you look, this is a difficult question. It has to be tested in a court of law. Let me tell you. It has to be tested in a court of law. If you look at the decision of the Supreme Court in Eicher Motors, 106 ELT3. Eicher Motors, what did they say? If a credit is availed, it is a right which accrues to you. Eicher Motors, 106 ELT, page 3. It's a credit which accrues to you. When the credit accrues to you, you cannot be disentitled to the credit after that. It becomes a right which accrues to you. There has to be a specific provision in law which takes away the credit. It is because of that they brought into effect 11 bracket 1, 11 bracket 2, 11 bracket 3. The Eicher Motors decision actually led to the introduction of Rule 11. They had a similar provision in 57F4 of the rules then. 57F4. That led to this 11 bracket 2, 3, 4 where they disentitled credit to be carried forward. So in this question, whether the credit can be carried forward for subsequent set-off, my view, it can be done. All that is reverse, asking for a reversal of a credit on input side is perfect. Asking for a lapse of the entire credit, which has been validly earned and set off in the earlier years, cannot be done by virtue of the decision of the Supreme Court in Eicher Motors case. They should have specifically said of the entire credit, including input, capital goods and services credit. So that is my view. This view will be contestable. The fifth question, as I told you in the introduction itself, the SENVAT credit rules have been recast with effect from 1/4/2011, restricting the credit to certain sectors. Now, if you look at this, three heads are there: renting of cabs for transporting employees. This is one of the most, I may use the word, stupidest amendments that have been made by some babu sitting in Delhi. I cannot imagine anybody working in the BPO or the IT industry today, or for that matter any factory, not having to use renting facility. They have to do it. It's a necessity. It is not even an activity relating to business, which was there earlier. It is a necessity. Nevertheless, the stupid provision is there because there is an exclusion to input services. The only issue which comes here is this. If I am the person who renders the service and it is a capital goods for me. The capital goods, what do you mean by capital goods? If you look at Rule 2, it says that it should be registered in the name of the service provider. If I am rendering rental services of taxis, if that particular vehicle is registered in my name, then that is an eligible capital goods. I can take credit. Actually, this was very well analyzed by one of the groups when I was there. Very well analyzed. Where they tried to read these two provisions, which were disparate. Now, this, in fact, when this question was framed and we had an argument in office over this. If we look at this definition of input services, what does it say? Service provided by way of renting of a motor vehicle, in so far as they relate to a motor vehicle which is not a capital goods. Now the question is, which is not a capital goods for whom? Service provider or the service receiver? Input, when I am talking of input services, when I am wanting to take the credit, let me say that I am the manufacturer and you are providing rental services. Right? Now, I am taking the same as an employer, I am asking him to use that car services. The thing is, the service is being provided by you. In so far as they relate to a motor vehicle which is not a capital goods. It's a capital goods for you, not for me. If it's not a capital goods for me, I can't take the credit, even on the services, because the input services and capital goods were aligned in 2011. If you can't take credit here, you can't take credit there. That was the theoretical way it was put. Now let's come to a situation where I recover some money from him. Can it be said that I am rendering the service? Can it be said that I am rendering the service? Can it be said that I am rendering the service? In the definition of service, employee to employer is out of the definition of service. Employer to employee is not out of the definition of service. So can it be said I am rendering a service to him and therefore recovering an amount? Even assuming that so, because in this example I would have probably said I am paying service tax. Yes, service tax is paid on such collections. Assuming so, can it be then said, even if it is not capital goods it is not registered in my name, I am providing the services of renting a cab. In turn, somebody else is providing the services of renting a cab. I am not taking capital goods credit. I am only taking input services credit. And because you have not specified in whose hands this should be owner, I can jolly well take the credit if I am recovering tax from somebody else. This is one view. I subscribe to this view. This is one view and I subscribe to that view. If there is no recovery being made, then I am on sticky wicket because absolutely the service is being rendered by you to him, effectively. Here also, of course, this will be subjected to litigation, and let me tell you I should also tell you the chances of winning this litigation is less than 10%. Let me frankly tell you, going by the current crop of what is going on, this is such a long-winded argument that I should do that nobody will have the patience to listen to me except this crowd which is sitting here. The higher the courts you go, the lesser is your latitude to give intellectual arguments. So as far as renting of cars is concerned, you don't stand a very good chance to get the credit as the rules have been framed as of now. Let's look at security services meant for the residential colony. No, there were some very interesting arguments which were taken in all the groups, I must say. Security services is already listed as a input service. If you see the definition of input services, what is the change between prior to 2011 and after 2011? What is the change? Prior to 2011, it was very wide. It included activities relating to business. Any activity relating to business was included in input services. But after 2011, it has become a means and includes definition and excludes. Exhaustive definition. With some exclusions, that is how I would say. Security services, however, finds mention over there. One of the, I think there was a Gujarat High Court decision and a Bombay High Court decision, Manikarg Cements case, where they said that these are welfare activities. No, where is it said in Senvat credit rules that welfare activities you cannot take credit? Nowhere it is said. I am unable to understand the reasoning of some of our high courts in this country. They say only a factory above 250 canteen services you will be given credit. Where does it say below 250 you cannot take credit? Where is it said? Where is it said that if something is not compelled by the statute, it is not an exigency for you? Nowhere it is said. It is an absolutely wrong, I'm sorry to say this, but it's absolutely wrong, these decisions. On the contrary, I heard somebody mentioning this ITC's case. You take Andhra Pradesh High Court, ITC's case, 32 STR. The Andhra Pradesh High Court clearly said that it was a business exigency, effectively. Security services meant for the residential colony, the first argument that we should, and some of you happily took it, whose colony is it? Is it the employee's colony or is it my colony? It is in my balance sheet. Come on. Not only the security, if you have insurance, that also should be eligible for credit. On the simple ground that it is a business asset. And I have the necessity to protect that business asset. On that grounds itself, credit should be given. So in my view, it falls under the inclusive clause itself. There is no need to go to the exclusion clause at all. Because there is no, it is not meant primarily for the consumption of any employee. No. It is meant primarily for my own consumption. Whether the MD requires security or he does not require security is a decision to be taken by the company. One of the things which was being discussed about the MD having to take security and other things, it is a business necessity for me if I want the MD. If I don't want the MD, I won't give him security. Simple as that. If I have given him security, it's a business exigency. So whether it is recovered, not recovered, whatever it is, security services are eligible for credit in my view. Food facilities provided to the person. Now, typically this means that an outdoor caterer will come, cater over there and give his bill. Here also, the question is whether it is meant primarily for the consumption of an employee Or because my factory is located in a remote area, it is a necessity for me to give him, otherwise I can't retain that employee. I was giving an example yesterday, this is prior to 2011 of course, to some of my friends. Guest house facility is being maintained by a company. We had a matter before the Commissioner Appeals, so when I went to the Commissioner Appeals, I told them, please bring your superintendent. And he said, why? I said, please bring. He came. So I asked just one question. When you go to that cement factory from Hyderabad to somewhere, where do you stay? He said, in your company's guest house. If you find it expedient to stay in the company's guest house, what about the others? And so maintenance of company's guest house, why would I, see one thing I can't understand is this. Why would anybody incur an expenditure if it were not necessary? And who is to test whether this is necessary or not? These are two questions we should ask, or any court should ask. If I am incurring an expenditure, what is the necessity? Who is to judge the necessity? Is it the taxpayer or is it the tax administrator? We all say payer. Some IAS man says it's me. I decide who will give the credit or take the credit. I am the data. It's very unfortunate. This Sunwide credit, I'm telling you, I think I will die fighting Sunwide credit cases. No, at this rate, no. After this negative list came, I'm really telling you, I do not know. Every seminar, every lecture is a learning experience for me. The questions that were asked by our friend from Nashik, for example, beautiful questions he asked. Development right, actually what he asked, transfer of development right. When one developer is already having the rights with the landlord, he admits another man. It is nothing but transfer of development right. Now, is transfer of development right subjected to service tax? That is the question. That should have been the question you should have asked. When I cede away my 100% rights to another developer, and then we do it jointly, and therefore you collect a premium from him, is it transfer of development rights? That is the question you should have asked. I don't know if that is what you meant. No, I'm just telling you, so interesting this, I don't want to enter into his shoes. That would be wrong for me to do so. Transfer of development rights, would it be subjected to service tax? See, why I'm telling you is, I'm at wit's end. The topic itself is so complicated. Because, by passing a reference, I will tell you, there is the decision of the Bombay High Court in Chajjad housing. CHAJED, Chajjad housing. This is in, how you pronounce it is for you people to correct me. Because I don't know please excuse me for the pronunciation, I come from south. This is in the context of the specific relief act. With your permission, I will just answer it, sir. The issue was, in development right, a person wanted to enforce it. Let us say you transfer the development right and then go back on it. Person wanted to enforce the development right, saying he has already entered into an agreement to cede the development right, it should be enforceable. Now, whether it is enforceable or damages is enough. In specific relief act, if you see, if damages are sufficient, they will not enforce the contract specifically. If damages are not sufficient, the contract will be enforced. And if it's a contract for immovable property, it will be enforced. So the question in that was whether development rights is an immovable property. What the Bombay, have you understood this? So what the Bombay High Court said was this. Under the Transfer of Property Act, immovable property also includes benefits that arise out of land. So they said a development right is a benefit which arises out of land and therefore becomes immovable property, and therefore it can be specifically enforced. Therefore, if in your case it is an immovable property, then it's a transfer of title in immovable property, it's not a service. Now coming back to my subject. This is one view. This is one view. I'm not saying this is the view. This is one view. So if you transfer development rights, it's a benefit that arises out of land and therefore there is no service tax because it's a transfer of title in immovable property. One view.
So the judgment was Cheda construction.
I would not know these, I can't pronounce or spell those, It's very difficult for me. If I go beyond Andhra, I am lost. Huh?
It is mutual.
Yes, everything is mutual here. So if you look at that decision, you use it.
Yeah.
Use it.
You use this, sir.
Please use it. Now we will come to healthcare. No, did I finish the food services? So I'm sorry, see, I get carried away. Cut me short if I get carried away somewhere. How much time? I have some time? I have a lot of time, don't worry. Now, food facilities, if you see, in my view, this is purely my view. In my view, food facilities that are given, outdoor catering or whatever that is given, is a business necessity. It is used for providing output service. My view is this: if I don't give him lunch, he will not work. Business retaining employees. Retention of employees, one of the easy, people work 12 to 14 hours. Can you expect them to go, if they go out for food and come, it's going to be 1.5 hours. Give them the food in the canteen, it will be a matter of half an hour. So what are you doing? You are just saving time for yourself. In my view, it is a service used for providing output service. You may say, how is it linked to the, where is the nexus? I know that most of the tribunals in this country will say there is no nexus between providing food and the service being rendered or whatever is the output which is being rendered. Let me tell you, but can you work without food? Here also I feel the test should be each business, whether it is required to run it the way they want or not. That should be the test. It should not be the test viewed from the judge's point of view, whether it is necessary or not necessary, keeping in mind his background and his family, orientation. It should be what that man wants and what that man's orientation is. So, I should also tell you practically, what is the chances of you winning in litigation is less than 10%. Because the way that has been worded, the exclusion clause has been worded, which shows outdoor catering, very clearly says it is primarily meant for consumption of employees. So your chance of winning in this food facilities is very less, but I would still say contest it because it will add to the growth of case laws. Yes, sir.
Other than those actors which are excluded, everything is included, we can take that away?
Please do it. See, I follow a simple principle in Senvat credit rules. When in doubt, take Senvat credit. When in doubt, take Senvat credit. When you're not in doubt, anyway you're taking the credit. That's the easiest way in Senvat credit. Let somebody pick it up and you fight it. Now coming to the sixth question, yes sir.
One doubt. Say clause
glossy of the exclusion, when such services are primarily used for personal consumption,
Yeah.
that applies to only the last part of the glossy or the complete, all the items listed in glossy.
All the items.
All the items.
Yeah. I am of the view that is listed, that is meant for all the, it qualifies all the items, including outdoor catering, everything. Yes, beauty treatment. Let me tell you, see, you take your TV anchor people, for example. Without that beauty treatment, is it possible for you to see them? I'm sorry. I mean, is it possible? It is an absolute necessity. Whether male or female, you know that with makeup, some people look good and without, you can't recognize them. It is an absolute necessity. We can't look at our actors and actresses without the makeup. We have got used to that. It's a necessity. It's a business necessity for them, a professional hazard for them, let me say.
But still, will it amount to personal use?
In my view, it is not a personal use because none of them are putting it up because they want to look good. They have to look good so that the TV ratings will go up.
Business requirement.
It is a business requirement for the channel. It's a business requirement for the channel. So in my view, the test for any of this will be whether the business needs it or whether the employee needs it. If it is the business which needs it, credit should be allowed. You may ask me then, what is it that the employee needs? Everything is business means, what is the use of that exclusion clause? That will be the next question. If you say that it's all a business exigency, then why need that exclusion clause at all? It's a good question to ask, but I am not going to answer it because it is for the government to answer it. If you have included an exclusion clause, you tell me why you have done it. I am not going to answer it. If you see the case of Majestic Mobikes, which I had an opportunity to argue, the issue was this. This is why that amendment came about in section 80 of the Finance Act. Notwithstanding anything contained in section 76, 77 or 78, that is how it starts. No penalty shall be levied if there is reasonable cause. We stop there. So this matter, when it came up to the tribunal, I said, even if there is a collusion, even if there is suppression, if there is reasonable cause, no penalty shall be levied. Because there is a non-obstante clause which refers to section 78. Departmental officer said, sir, your lordship, if there is a collusion and there is a evasion, how can there be reasonable cause? So I told the judge only this. Service tax was introduced in 94 when compliance is very low. Now we are in 2000, 2001, 7 years, 8 years. Compliance is very low. So even if there is collusion, we will let you off if you pay the tax. Provided we will waive the penalty under 80 and say that there is reasonable cause. That is the reason for which section 80 was introduced. So that people will comply with tax. If you tell them, if you go to a consultant and he tells you you have to pay tax, you have to pay mandatory penalty, nobody will comply with the tax. Nobody will comply with the tax. If you tell him you come pay 100% penalty. To make him comply with the tax, you introduced a notwithstanding 78, I will still waive. And Majestic Mobikes, they said yes. This was upheld by the Karnataka High Court. Then they made the change saying except, I think, proviso to section 78, you will see that. That was introduced to get over Majestic Mobikes case. Now we'll come to question 6 is a fairly easy question. I think all of you have got it completely right. In the sense, I would not say right, your understanding is in sync with my understanding. There's nothing like right or wrong here. It is in sync with my understanding, that's all. Essentially, see, I remembered, I had one matter where a false ceiling was being put up for the purpose of air conditioning in a 100% EOU. The issue was whether you can call it capital goods under the notification 52/2003 or other notifications which are there in customs. So I had argued on the question of technical necessity. 100% EOU requires a false ceiling with an air conditioning as a technical necessity. If there is something without which, you take the celebrated case of JK Industries case. If you cannot carry out a process in the manner in which it should be carried out, this comes in 91 ELT, JK, but actually it's a very old case, AR in 1963 or 61 you will find this. Very old case, say in the sales tax. If something is necessary for your production or manufacture, then that will constitute an input. That is JK Industries case. This is a ratio. So if something is a technical necessity, it is essential. Why I included this question, however, was just to see whether you are looking at it as a technical necessity, is it a condition for this? I do not know if you people discuss this. Is the present set of SENVAT credit rules based on technical necessity as far as capital goods are concerned? That was the question. Even if it is not a necessity, but it is used in my factory or used in the office of the service provider, can I take SENVAT credit? Yes. I don't need to justify technical necessity anymore. Capital goods used for providing output service, over. But when it comes to the usage, used, there the technical necessity comes. I want you to take this distinction. When I say use, that means it should be used for providing. Then the technical necessity comes. So therefore, you are all absolutely right in saying that this air conditioning equipment for controlled temperature conditions is a necessity. Not only is a necessity, but if it is found in my premises, automatically I am entitled to capital goods credit. That is my view. Coming to question 7, that question 7 was deliberately designed to give a surplusage as well as to show you the difficulties of the LTU vis-a-vis ISD scheme. Because many assessees have created certain, they have gone wrong. Let us look at these two schemes. LTU is a self-contained scheme. If you go under LTU for all your services and manufacture, this particular client would not have fallen into this problem at all. If you go for your LTU for all your units, the question of going for ISD does not arise. Why? Why? Because in the LTU, you have a specific provision in SENVAT credit rules which allows you to issue transfer challans between the units. There is no need for you to go to ISD at all. What has happened here is a typical live example. The first two, you just take these 4. In this, the first 2, that is manufacturing units at Ahmedabad, Bangalore and Belgaum and Bangalore, marketing and service providing units, Mumbai and Delhi, these were all registered as LTUs. Under the LTU scheme, I declared all of these people. Typically, I would have opened a marketing office later on in Noida, Calcutta, Chennai, wherever it is. Or I would have forgotten to include these units as LTU. I would have simply forgotten. I have registered my Bangalore as an ISD. This ISD would have continued, I would have got the ISD registration done first and then would have gone for LTU. Now if you look at registration of special persons category rules 2005, you look at that carefully. I believe that this may not, I don't know if this was discussed. This may not have been, did you discuss this? In that it says, the provisions of rules 4 bracket 2 to 4 bracket 8 of the service tax rules will apply. 4 bracket 2 has to deal with centralized registration. So even if I have made a mistake, the provisions of centralized registration will apply even to ISDs. If I have registered centrally at any unit, I can take credit for any of the units, wherever it is received. Dehorse the LTU. Under the ISD scheme, if I am centrally registered, what is the question here? At Bangalore, I am paying all the taxes under the ISD. I want to distribute the credit. Even though I am registered as an LTU, I may still want to distribute the credit to the factory and then payment comes. Payment is made. I receive an invoice which is in the name of Noida. That is not registered as an ISD. Right? But I have centralized registration provisions which will include even the ISD. That is what is the answer here. The centralized registration that I take is valid not only for my service provision, it is valid even for my ISD. Because the registration of special persons category rule says the provisions of 4 bracket 2 will be applicable. Have you understood this? And therefore, I can take credit on any of the documents that come anywhere. There is no need for me to get into any of this, get into arguments saying after all it's a technical flaw. There is no flaw. There is no lapse. The only lapse that has been created by this man is he should have included everything in LTU and closed this chapter. Then he can issue transfer challans without this ISD necessity at all. Eighth question. This is a very interesting question, the eighth one. Your answers were also very good. I was very happy with your answers. Now, the question is whether rule 6 bracket 3b will operate and he can take 50% of the credit relating to the inputs also, or at the threshold itself it is knocked out. At the threshold itself it is knocked out, it is not at all an input. This is the question. I think the identification of this question was done beautifully by all the participants. I was very happy with that. Solution is not happy. Any solution in CENVAT credit which says that you are not entitled to the credit, I am not going to take it. You may have, I have my personal convictions, like everybody has his personal convictions. I have a conviction that any credit should be taken. Huh? Every credit should be taken when in doubt. I will tell you why. See, the arguments are very good. When you go to the definition of output service, it says any service which is included in section 66D is not an output service, correct? So perfectly alright. So input, when you come to rule 3, the input should be used for the purpose of providing the output service. Now your argument is it's an output service does not include trading of coins, which is included in the negative list, and therefore there is no question of taking credit because not at all an input. What is exempt service? Why have you not looked at exempt services? Exempt service includes a service on which no tax is leviable under section 66B. Correct? Those which are included in the negative list, no tax is leviable under 66B. Why can't it be called exempt services? That is my first question. It may not be an output service, but it could be an exempt service. But then you will say, rule 3, it says that it should be used for providing output service. It does not say exempt service. Correct? Yes, sir, please. Please tell me, because it's a very important question. Please tell me. What is your observation?
One of the observations would be that the output service is already included in the definition of an exempt service.
No. Exempt service has its own definition. Output service has its own definition. They will say, rule 3 specifically says output service. It does not say exempt service. How do you answer that? How do you answer? Come to rule 6. Somebody said rule 6 after all is only a mechanism. This was the view then. Rule 6 is an obligation. That is how I read it. Please see the heading. Obligation. Is it right, sir? Rule 6 is an obligation. Now, you please look at explanation 1 to rule 6.3d. What is value? Explanation 1 to rule 6.3d. What is value? Correct? Value for the purpose includes trading. What is this? Have you found it? In case of trading, they take the margin, that's the margin, and also they say it could be 10%, whichever is higher. And then there is one clause in trading in securities with 1% and other things. My question to you is that if this CENVAT credit rules never envisaged credit to be taken, then why do you include this? If it has to be knocked out at the threshold, why do you require this in say 6?
This was a common input services.
No, I disagree with you. Rule 6 does not say common input services. Where does it say?
It doesn't say, but by implication.
No implications, sir. That was earlier. No implications.
So even about the service, sir, I beg to differ from one point.
Oh yes, please, sir. We are here to beg. We keep on begging to differ only. Please.
Because you are taking that trading is a service, but I go to the 65B44 itself, which says the transfer of the title is a movable property.
Yes.
Is excluded from the definition of service.
Then I am not at all saying no. You see how the negative list is worded. The negative list shall comprise of the following services. 66D. So that means by implication trading is a service. As per the negative list. As per the Finance Act. When I come to CENVAT credit rules, the definition of service is not incorporated in CENVAT credit rules. Even if there is no transfer of title, or even if there is transfer of title in immovable property, it is not at all a service there. Here, in rule 6, they include it as a service for the purpose of reversal, for the purpose of your obligation. It is a self-contained code, Raghuvar India's case, Supreme Court. ModVat. Therefore, it need not be a service. You are right in saying transfer of title in goods. It's not a service at all. 65B 44. Absolutely right. But they have included it as a service in negative list. They have also included it as a service in exempted services. They have also said if it is used in exempted services, reversal should be done. If that be the case, they have included trading as a good. There is a salutary principle in law that no words of the legislature is wasted, though the time of the legislature is wasted. If that is the case, you cannot say trading is a surplusage. If you cannot say it's a surplusage and therefore it is included in 6, otherwise how will you calculate that formula? You have to include trading. So in my opinion, you should use what one of your mentors said, and you brushed this aside. One of your mentors, I don't know if he is here, said, the business of banking includes trading in gold coins. Use that to say, I am a provider of output service. May not be this, but I am providing output service. I am a provider of output service. And therefore, in my view, operate the 6 bracket 3B, rule 6 bracket 3B, take 50% even on your inputs and lend your name to a famous case. You're right, you are, there's a highly arguable, this is the reason why I gave this example, because this is going to be a hotly contested topic between the department and the assessee on the interpretation of Rule 3, output service, exempt service, Rule 6 and 65B 44. It is going to be a hotly contested. 50-50, not 10-90, 50-50. This has a good chance of you getting some relief over here, I feel, at least from what arguments I have led on Rule 6 in the past. I believe you have a very, very good arguable case on this.
Sir, only one reservation here.
Yes, sir.
This trading, whatever you are saying the value, that comes by way of an explanation, sir. It is never in the main provisions or main section, sir. There is only an explanation that if you treat the trading as a service, you take this one. It is only for valuing the trading.
There is a decision of the Supreme Court in 43 ELT. Afali Pharmaceuticals case. Afali Pharmaceuticals case. Explanation is part of the section. Explanation is part of the section. If it is a part of the section, we have to give effect to it. If you have to give effect to it, if I am having a trading income, that means the CENVAT credit rules have envisaged that trading is a possibility. Is a possibility for you. And they have included 6 bracket 1 to say what is exclusively used in exempt should be taken out. They have also said 6.3b, notwithstanding anything in sub-rule 1, 2 or 3. Who asked them to do all this? So my view is 50% we take credit.
Will you give me 1 minute again, sir?
Yes, you please, how many ever you want to, because it's a very important topic.
Because I believe this explanation has come because of the Orion appliances. Because before Orion appliances case, when there was, that judgment says there was no mechanism.
Correct. Absolutely.
Knock off the trading.
Absolutely.
Trading.
Yes.
So it should be done on some reasonable basis. That was the,
Mr. Murthy's decision, I think.
Yeah, previous Murthy's decision. Yes. So I believe that
it's a single member decision. It is binding on us, no doubt about it. But the fact of the matter is, you see BC Srinivasa Shetty's case. If there is no 128 ITR, if there is no mechanism, the levy is not contemplated. Therefore, if the mechanism is put, levy is contemplated. Right? If your mechanism is put in place, that means you contemplate that you can take credit on trading. Use it to your advantage.
not take the tail will take
The tail will have to wag the dog. Because tail is an important part of the... Can you straighten the tail? You can never do it. So tail is also part of the... I do see there are decisions both ways like this. Explanation is it should expound, not expand. At the same time, there are decisions of Supreme Court which say if the explanation, the wordings are very clear, it should be given effect to. So, notwithstanding the dog principle, yes, I still feel 6 bracket 3b should be given effect to. This is my view. Now, the last question on reverse charge mechanism, I think all of you are very clear that no, I'm sorry. One of you were saying that prior to 1/7/2010 you can utilize the credit, and after 1/7/2012 you cannot. Prior to 1/7/2012 you can use the credit, and after 1/7/2012 you cannot. Well, the other two said it is not eligible at all. My view is this. If you look at Rule 2R of the Senvat credit rules, provider of taxable services includes a person liable to pay tax. Person liable to pay tax is defined in Rule 2(1)D of the Service Tax Rules 1944. To include a person liable to pay tax under the reverse charge mechanism. So he becomes a provider of taxable service. If he becomes a provider of taxable service prior to 1/7/2012, he is also liable to pay tax, and therefore he can use his Senvat credit for discharging tax on output service. So prior to 1/7/2012, he could have used Senvat credit. There is a decision of the Karnataka High Court in Arvind Mills case, 23 STR, which supports this. Broadly supports it. Only where it was barred was the GTA. Nahar Spinning Mills, Punjab and Haryana High Court decision is there. Only the GTAs were barred. The others could use to pay tax or even on the reverse charge mechanism. But after 1/7/2012, they have barred this reverse charge mechanism subject to what I told you in the first question. Whether it will apply for partial charge or full thing, that has to be seen. But in case of import of services, let me also tell you, this is on utilization of credit, but food for thought. Is there any charging provision for import of services? Is there a charging section today after 1/7/2012? I ask you this question because why should I not ask you one more question? Is there a charging section post 1/7/2012 for import of services? It's not there. There is only a payment mechanism which is prescribed in 68 bracket 2. That is on the liability. Chargeability is not there. And therefore, that entire reverse charge mechanism as regards imports is set to fail if it is challenged. Yes, sir.
So just one, this charging section now uses the word provided in the taxable territory.
Yes.
In order to decide whether to provide in the taxable territory, we have to refer to the progress of provision. So import after 1/7/2012, can one take a view that once, as per the POPS rules, if it was the taxable territory, the charging mechanism is already embedded in section?
In my view, the POP will decide only where the services are provided. Where the services are provided. I am aware of this view that the government says the central government is delegated with, they can make rules where the service is provided in the taxable territory or outside the taxable territory. Fact of the matter is that there is no charging section if the service is provided outside the taxable territory but the recipient is in India. I will give you an example. Let us assume that I am a head office. I get a contract from a client in UK to execute a software project for, say, lakh rupees. Part of the execution is done by my branch in UK itself. Right? Perfect? Now, as far as the payments that are done to the branch in UK for services which are rendered outside India, where I am the beneficiary, but the actual recipient of the service is also outside India, can it be brought to tax? The service is not rendered in the taxable territory. Can you, by relying on 66C, say that it is rendered in the taxable territory? No. And therefore, whatever component, even if I were to remit the amount from India, let us say, because I get the total consideration from the foreign person, even if I were to remit the amount from India, the service is not rendered in the taxable territory. And therefore, there is no tax will fall on services rendered by a branch to a foreign entity, even if the payment is routed through me. Think about this. So I thank you for the opportunity, and I would like you to ask me any questions that are there. Thank you.
Sir, in the first question, there was one poser which has remained unanswered.
I must have forgotten. Tell me.
The question was, the input service definition, there is an exclusion for insofar as the works contract services are concerned. Now, when I am building a mall, I am not aware as to whether I am utilizing it for the purpose of, as a construction service or for the purpose of letting out. So there are two services I am envisaging as an output service. One is construction service and other is renting of a movable property. And I am against that I am having one common input, that is a construction service. As
some of it, essentially it would mean this, sir.
Yeah.
Let me take it forward. What you probably mean is this: when I have a commercial premise which I am building, some of it I may sell out and some of it I may rent out. When I am actually constructing it, I do not know whether I am going to sell or rent out. I don't know about it. Right? So I take the entire credit. Or after having taken the entire credit, should I proportionately reverse it is the question that you are asking.
Yes.
Right?
Yes.
That is the question you are asking. My view. My view is answered by somebody. Avail the credit. At the time of taking credit, what is your intention?
Suppose the intention is both.
Is it expressed in any document? I leave it at that. It's for you to do the tax planning, and it is for you to also face the consequences of such tax planning.
Would it also apply to the flats sold after completion certificate?
In my view, let me tell you, in my view, you are entitled to the full credit, because in a flat transaction normally, nobody envisages that he will wait till the end to sell it. See, his cash flow will be so seriously affected. So when you start a flat project, your normal intention would be, if you are collecting advances, let us say from 100 people, you would also expect that the other 100 flats, say you have 200 flats, you will expect that it would be sold, you will like it that way. It's another thing that you may not be able to sell it and you will be forced to sell it after completion. The fact remains that, in my view, the fact remains that if you have started receiving the advances and you have taken it that it is a service under 66E subclass B or under H, as the case may be, my view is you are entitled to the 100% credit. And there is no need to reverse even if you are selling something after such a long time, because you had never had that intention. You never had that intention. That is my view. Yes, sir.
The same, because another variance of this, entertainment industry facing this problem. When you are making the film, and now the theatrical rights are exempted,
Correct.
and all satellite rights, other rights, music rights are taxable. So at this stage, while making the film, it is project of 2 to 3 years, sir. And the cents are captured at that stage. At that stage, I am not knowing whether I will be selling the theatrical rights, I will be selling the satellite right, which proportion, what not, sir.
But primarily you are making it so that it will run in the multiplexes. That is where most of your revenue.
Nowadays, if you go by the industry, the satellite rights, video rights, and there are
more than box office collections.
Yes, box office collections.
Very good. Take the credit. I have told you.
So
the answer is clear.
That is, so in that case, this is a practical problem, sir.
Yeah, no, I agree with you. See, you are going to have cases under Rule 6. Any of these matters will come up, and there, by intention, you will have to establish that I never had this intention. In fact, this construction, to take it further, see this provision which he said there was deeming fiction was there, and now they have put it into 66, the subclass B. Really, that has been borrowed directly from the UK VAT 1994. In UK VAT 1994, there is a clause which specifically says it will amount to a service if it is done, if any consideration is received prior to completion of the project. So this is direct. That explanation which was added on 1/7/2010 was just a lift from there, so that they will tax the builders and developers. The intention was to tax builders and developers who pre-sell the flat. That is why, they bought that explanation. That is the reason why it is there. So in my view, if you are collecting the advances as far as he is concerned, I think he should be able to take the credit. As far as the film industry is concerned, they also have to say my intention was to give only no theatrical rights, which will be difficult to establish. He is on better footing than you.
Service tax is applicable to the theatrical rights also. Your question is only up to before 1st April 30. Right?
Yes, sir.
My question is regarding the exemption mega notification 25, item number 19 about the canteen. Industrial canteen.
19 or 19A?
Now 19 has been added with 19A by virtue of the October notification of 14. Now the canteen run by the factory. My question...
Without air conditioning. Without air conditioning. That is your question?
Without air conditioning. Now my questions are two. When the canteen contractor is appointed, what will be his role? Whether he will be taxed under service tax? Who is giving services to the industrial canteen?
He is an outdoor caterer.
But he is sitting in that canteen.
He is whether it is provided in his premise or any other premise. That is what it was earlier, outdoor caterer.
Company has allotted him the premises.
Perfectly all right.
And
he is still an outdoor caterer. It is not his premise.
So, my question, because you are very much optimistic and we are very happy with that. See,
please don't import my optimism into your optimism. I am optimistic because I see so many cases will come.
Yeah, and those are our bread butter. That is the case over there. See, what 19A says that canteen run by the factory. It does not mean that the factory people should run it. Correct. They can hire the canteen contractor who bills to the factory itself, not to the employees. In that situation, the canteen contractor should also be exempted according to my views.
Yes, your view is very, very reasonable.
Sorry to interrupt, sir, but this issue has already been taken in paper 3, so we can discuss at that.
Okay.
It's okay. So if you don't, I have my view, I think I support what he says.
Thanks.
And let me also tell you, if there is a recovery from the employee,
Yeah.
I will go one step further. Make it a recovery for the food. No service component will be there. Please think about it.
Okay, thank you.
Yes, sir. Any further questions you have? Kerala High Court decision on the constitutional validity which you find. See, what is that entry? 66E, that is the 9th entry. HI. Service portion. Service portion in the supply of any food. That is how it is. The service portion in the supply as a part of. So essentially it should be a service in which food is supplied. That is the entry. It's not the other way around. It's not the food which is being supplied, service being incidental. No. Service portion in which supply of food or beverages, whether intoxicating or not, is a part. So Kerala High Court said it is a deemed sale and therefore it is invalid, constitutionally invalid to charge service tax. They have not, I think in my view, noticed that in BSNL's case, the Supreme Court said 2 contracts can be vivisected. One is the works contract and the other is catering contracts. So catering contract can be vivisected. What should have actually been argued there in Kerala High Court to sustain the, to say that it is constitutionally invalid is that when you serve food in a restaurant, there is no service at all. Can you say that? If you cannot say that, then the judgment of the Kerala High Court will fail. You take a self-service canteen, you go, you stand darshanis, which you go stand, eat food and go away. There, it's only the sale of food. But if you go to a restaurant, sit there, somebody comes, serves you, can you say there is no service element? So in my view, I believe that the Kerala High Court decision may get set aside. Because vivisection is possible for catering contracts, as per the BSNL's decision. One has to, however, see whether what other justifications they can bring about when the matter goes in appeal. You can use it, it's persuasive value, you can use it till such time it is, it's set aside, but be careful, interest will always accrue. Penalty will not be there, interest will accrue if you are liable for interest.
Sir, one of the query was on the canteen services. And in that, the fact of the case where, in the query itself, you said some recovery is made from the workers. So, sir, would you think that Ultratech cement decision, Bombay High Court, wherein the Bombay High Court has held, whatever you recover from the workers or laborers, the salvage is to be reversed to the extent.
To extent it is not recovered.
It is to the extent?
It is not recovered. If it is recovered, there is no problem.
No, sir, it is recovered in the sense, if I am, the 10 lakh rupees a bill of the canteen contractor.
You are saying to that extent is recovered, proportionate credit will have to be reversed. That's what you are saying.
Yes. So, sir, what is your view on that? Because ultimately, the tax incidence has been borne entirely by the company.
I fully agree with you. You see, this Manikar cement. And one more decision, Ultratech, if I am not mistaken, it is the same judge who sat on both those. On one he said input service you should follow Maruti, and another he said it should not follow. I'm sorry to say, I don't want to comment more than this. Because it is these kind of judgments which actually upset the Sunvat credit. You are absolutely right, every company bears the incidence. In fact, what they should have said is what is recovered is the cost of the food and not the service element. And then the credit should have been taken fully. That is what they should have said. Yes, sir. Please ask me. Yeah, please.
So my question is not to the salary actually. My question is whether this recovery of notice period salary from employee by the employer is taxable?
What is it, sir?
Sir,
I should restrict myself?
we should restrict question only there in respect of Senate only.
Okay.
This is covered in tomorrow's paper.
Tomorrow's paper also, otherwise also restrict.
Let me not step into somebody else's shoes is what he's saying very succinctly. I'm okay with that. I'm okay with either.
So there was one issue relating to the interpretation of the definition of input service. As there are three limbs to the definition now, the means limb, includes limb and excludes
It's
limb.
been referred to the larger bench by the Supreme Court. Kisan Sahakari Mills case, they referred the Maruti Suzuki's decision to the larger bench because they disagreed with that reasoning in Maruti Suzuki's case. If I'm not mistaken, Maruti Suzuki said there are three limbs and it should fit there and other things. But the bench of Justice D.K. Jain differed with that and referred the matter to the larger bench.
No, but the question was that exclusion limb, whether if something like the renting example that we took earlier, that I have constructed a mall, my intention is to let out the mall for the first instance. Right,
In my view, the exclusion will operate throughout.
So means clause also it would be.
It will operate throughout. Means and includes clause. It will operate throughout. It is not restricted only to the means or the inclusion clause, if that is your question.
But again, when you read the last exclusion post to exclusion, when for the personal use and consumption,
Yes.
it means you are going back to again,
Everything is interrelated. Everything is interrelated. What I'm saying when you say it excludes, that means it's out of the ambit of the first limb and the inclusive clause, and the exclusion clause should be then construed strictly to include only those uses for personal use. You cannot expand it beyond that. That is how you should interpret it, or I would interpret it at least. Yes, sir. Your question, sir. You had one more question. If you have time, you stood up, I thought, no? Yeah.
But I've been told that other than Senate credit.
But
my question is very simple.
All questions are simple here.
Answers is very. See, as per audit and service tax, there are certain criteria. Okay, less than 10,000, there will be auditing once in a 5 years. Now, I put up a question at Nasik Commissioners, Mr. Pandey, and I put out that circular there. So I told that your person comes for this criteria paper and they take for 5 years. Then why it is required? 5 years, I think it should be once in a 5 years, means in that 5 years he should check only 1 year. He said no, our person will come 5 years, once a 5 years, and will check all 5 years. No, but then what is the requirement of this circular? So he said throw it out. So I need your explanation.
Throw it out. My view is clear. Please ask them to audit for 5 years and go. They will miss most of the transactions. Then the subsequent time when they come, you can say, I had a bona fide belief. There is no suppression. Don't get into all these chota-mota things. Let them audit 10 years also. Please do it. They will not understand head or tail of what you have put in your balance sheet. Even after all the training, whatever they get or whatever we train them or which is all faltu, let me tell you, they will not be able to understand your balance sheets. Your profit and loss account. In fact, some of us, we ourselves don't know how to read the balance sheets. No, it has become so complicated. If you have been practicing service tax for so many years now, if you look at a balance sheet, I feel, why should I read all this, man? It is so complicated. So my view, leave them to do the audit. Yes, I haven't understood all those things still. And I'm happy that I have not understood service tax also. So it is all, I am on common wicket in both. Any other questions, sir?
Regarding capital goods and inputs, I required a little bit of explanation regarding the difference between the two. Inputs is related to excise duty and capital goods is also related to excise duty on capital goods. But if there is some equipment like barge or something which is not eligible for input under capital goods, but there is excise duty paid or there is CVD paid while importing that, and I use it for cargo handling or I use it for some service taxable activity,
you can take credit.
I still feel credit can be taken under input.
What is the item?
Equipment could be like a barge also, or could be a crane also.
A barge or a crane which you are using for the purpose of?
For my accounts purpose, it gets my capital good, but it is not covered as capital goods under SENVAT credit rules. It doesn't fall under the chapter heading of capital goods. Will I still get credit under input?
You see, you will have to, if an input, you refer to the definition of input. It does include capital goods. It does include. It excludes capital goods except certain things. You will look at it this way. Any goods used, but excludes capital goods except when used as parts or components in the manufacture of a final product. So it's only for manufacturer that they have excluded this thing. Now you are saying that your item is used for providing output service, essentially, and it doesn't fall in capital goods. It is excluded specifically.
It is not
It's not in one of the chapters, and therefore you want to say it is an input.
Yes.
Because it's, you know what you should do. There is a decision of the large bench of the tribunal, 86 ELT, Union Carbide. But this was rendered in the context of the earlier Modvat rules, 86 ELT. Union Carbide's case, the large bench said what is not covered in capital goods can get covered as inputs. In one of my own cases, Waters India, if you search that excuse, you can find this, Waters India. See, Waters India manufactures what is called a HPLC, High Performance Liquid Chromatograph, which is used for analyzing liquids and gases. Now, an essential part of this is a computer. The department said this computer is capital goods and denied me the credit. I took an alternative stance that this computer is an input for the HPLC. And the tribunal said, yes, the computer is an input for this HPLC because it is a component part of the equipment. So you try to say that you will fit under all goods used for providing the service, and say that this, without this barge or whatever it is, I will not be in a position to provide this service. Try that and use this decision. Probably you will get relief.
Thank you.
In rule 2L, the means clause, includes clause and the excludes clause. Now reading them together, if you say that excludes clause specifically excludes
capital goods,
then no, 2L excludes exclusion clause. There is a specific exclusion clause over and above inclusion and means clause.
2L, no?
Yeah, input service. Yeah. So it includes all the three types of provisions, means, inclusion, exclusion.
Correct.
By providing exclusions specifically, does it mean that barring those exclusions, everything will become a part of this availability of credit?
See, it is like this. Earlier to 2011, it would have been so. Now you have to fit it in the main class. You must show, see, you have an inclusive class. If your services fit in the inclusive class, you are automatically entitled for credit. Your question is, whatever is not there in the exclusion class, is it automatically becomes entitled for credit? Then you have to fit it in the main class, that is used by a provider of output service for providing an output service. Now usage is what you have to prove. That effectively means technical necessity. Yeah. So if you can prove the technical necessity of an item, you will be entitled to credit.
Yeah, that is offshoot of what you have said, that you claim on everything, and particularly if by going by that logic, there won't be any difference between prior to 1411 and post 1411.
See, prior to 14, I'll tell you, prior to 14-2011, I didn't have this difficulty because the definition said activity relating to business. I didn't have this difficulty. Now I have to justify the usage. Please see, that is the difference. Activities relating to business need not be directly used. Now I have to say that this is used. So that is the difficulty I am having. And by virtue of admissibility of credit, if you see Rule 9, the burden of proof is on me. In any of these things now, burden is on me to say that I am eligible for this NVAT credit. That is the issue. Yes, sir. So I think I have overshot the time, or I don't know. So I thank you very much for a very patient.
Thank you, Raghuraman sir. Very good afternoon to dignitaries on the dais, off the dais, and my dear friends. Few announcement first. A group photo will be taken immediately after this session. So request you all to assemble after this session in the lobby. Thereafter, afternoon tea and snacks will be served beside this hall at around 4:45. A cricket match has been scheduled, and all the participants who are interested can assemble nearby the swimming pool after wearing your sportswear and pumping in your sportsman slips. And so it's 3:30. You can assemble at 3:30 nearby swimming pool. Arrangement for DJ has been made, which will start at around 8 p.m., which will be followed by dinner in the open lawn, what we have behind the hotel. And it may be noted that tomorrow by 10:15 we need to vacate the rooms. So it is requested that to all the participants to pack their bags tonight itself and keep it ready, because tomorrow morning sharply at 8 we will be starting with the third group discussion, paper study. So request you all to be on time tomorrow morning itself. The breakfast timing will be 7 to 8 a.m. Now I request Raghuraman sir to felicitate the group leaders by giving them a memento for taking a painstaking job for leading the team, and also making the discussion much more interactive. I'll call the names. Mr. Mandar Telang from Parwana Group. Mr. Hemang Shah from Mastana Group. And Mr. Manish Gadia sir from Diwana Group. A special thanks to Manish Gadia sir to step in shoes of Mr. Virendra, who was supposed to lead the team. However, unfortunately, because of ligament tear in the midway of their travel, he was not able to reach, unfortunately. Special thanks to Manish Gadia sir to accepting our invitation and proposal in the last minute. Now coming on a present task of proposing a vote of thanks. Friends, it's a saying that knowing that a tomato is a fruit is a knowledge. However, not to use the said fruit, that is tomato, in a fruit salad is a wisdom. And I'm sure that all of you will agree that Raghuraman sir has helped us to build a bridge to fill the gap between the knowledge what we have for the provisions and the wisdom which can surely use by taking all the credit at the first step, and then we can litigate later on. With this, I request all of you to carry out a round of applause.